the first to know in Nsem-Pii TV.
Sir, Jebekaya NDC amanukuo no eba abemu no. Adeɛ baako a wɔn ɛhyɛ Ghanafoɔ ɛbɔ ne sɛ NPP amanukuo no mu mpanimfoɔ a wɔn edi sika no wɔn ɛwɔ kuo bi a yɛfrɛ no ora wɔn ebetumi agye sika ne nyinaa a ɛnya asɛm kotoa ɛnyɛ Samuel Okudzeto Ablakwa ne nkɔfoɔ document a ɔmode kɔma John Dramani Mahama ne adwene sɛ by now deɛ nka NPP mpanimfoɔ nyinaa egum so me na wɔka sɛ deɛ press conference ahodoɔ a akɔso ɛne nipa a yɛsɛ ɔmo US ka no zero prosecution imposi ade no nipa no koraa akɔpie mu wɔ court ne koraa nso na afei ayɛbɔ akyi bidu kwabena dubu ahen a okoko pie mu ɛwɔ court me na wɔka sɛ ni case no yɛgu so a edi a sign bia nso nkyerɛ koraa sɛ papa yi edifo no ɛna minority leader Afenyo etimi ede na no atom bi ene wan fans pe Dr. Dominic Ayine na de enko tie.
She wrote
that they should stop announcing
indeed
policies.
It's because you have a vigilant minority in the room.
Are you taking credit for that? For what the cabinet secretary?
Let the action speak for itself. Let the action speak for itself.
When and by the way, this is you making the reference to the point you made just last week when you had the joint program. No policy document has been submitted to Parliament for scrutiny.
Yes.
Then you mentioned them, Feed Ghana program, big push, 24 economy, 1 million coders.
So you see that government now says that ministers stop making announcement.
When cabinet has given approval.
So they now tell them that stop making announcement. Why did they tell them to stop?
But these were announced by the president. The ones that at least you isolated.
Well, we are
announced by the.
We are saying that you announce social intervention programs that are meant to help create jobs and make the people's life better. Our contention, most respectfully, is that since they assumed office, apart from the PR, when they are hot, they only come and then announce a so-called corruption they are investigating somewhere. That's their playbook now. Anytime government is under pressure, Attorney General would do a press conference.
You think that's
Attorney General's place is in the court. My respected friend, the MP, who is an Attorney General, and his deputy, I want them to know that their place is in the court.
But they also owe us a duty to update us, to be transparent.
Oh, please.
In what you're doing.
Please. When they are updating you and undermining the authority of the court and disrespecting the rights of people, pronouncing guilty even before going to court, perhaps they are waiting for Bafuboni to become a chief justice so that they control the court, which I'm finding, I wonder how they are going to achieve.
You're suggesting that if Bafuboni becomes the CJ, they'll
well, they've said so. They've said so. At least we hear them saying that they want their CJ and then they can have their preferred judges. That's what they are saying. But we wait to see. We wait to see. That is why they prefer to be in the media to talk about people's guilt. But it is not in their place to pronounce guilt. The rule of law requires a go to court, make a case. Do you remember the Tagore case?
Yes. In the MV Benjamin cocaine matter.
Correct, the Tagore case.
Yes.
Do you know the person who did the appeal? When Tagore was convicted by Doche, do you know who did the appeal?
Who?
The Attorney General. Yes, he, as a Legon professor, he took up the case on appeal. And one of the things that my Lord Apau said in the ruling, in the judgment of the court, was that the fact that a case becomes a subject matter of public discussion, gains notoriety in the public domain, does not whittle down that burden, that responsibility on prosecution to prove his case or to lead evidence on the essential ingredients. I'm sure the learned Attorney General perhaps has forgotten his own case he did. If he has not forgotten, then he should know that it is not how many times he does a press conference to crucify people that will send the people to jail.
But how do you draw the line between his mandate to be transparent and what you now pointing out that he may be crucifying people. He must definitely.
Who defines that so-called mandate to be transparent? Transparent on what?
He's acting on our behalf.
No. Let's.
So his domain is not
it.
only the court of competent
So
jurisdiction,
make a general announcement. Say that you are investigating this case. Is simplicity. In the American system that they use as a justification, they don't go into the details to the extent that it affects the rights of parties involved. They make their general announcement, follow it. They're saying they are copying from the American jurisprudence, where prosecution will come out to update the public. Very well. Nothing stops you from updating the public. After all, we are in an enterprise driven by public opinion and all that. People want to know what you are doing. I agree. But you should know the limits. So far, I don't think that they've been limiting themselves to just mere updates. They go on to pronounce guilt. To the extent that the Attorney General will be arguing in the public space that he will be confiscating. When you have not even secured conviction, how do you talk about confiscation of assets? So let's tread cautiously.
On that subject of oral, the last press conference was about the Buffer Stock Company CEO under the Akufo-Addo administration. The sort of evidence that the Attorney General put
Excuse me, hold on.
Allegations.
Evans, respectfully.
Yeah.
You see, this is it. And they managed to poison the minds of Ghanaians.
How do you also?
Listen, you've heard the Attorney General.
Yes.
Have you also given the gentleman and his wife the opportunity?
He issued a statement saying it's not true.
Yes.
Yes.
Simplicity. And you believe the Attorney General?
No, I'm just putting out what the Attorney General says.
But that is wrong. That is where the problem is.
No, but the Attorney General is the Attorney General.
No.
Is our Attorney General.
With respect, he is a politician. He wants his party to look good. All right? They did the same thing to Kwabena Dubois. Somebody who has spent all his life serving the states as a security couple. They came out to say all manner of things. But you know, there are things that are better not said. So it's okay.
What are you hiding?
Time will tell.
Well, what don't you want to say?
Oh, but you heard Donald Rumsfeld.
What does he say?
There are unknown knowns and there are known unknowns.
Yeah.
It's not everything from where
what are the known knowns?
I'm saying that from where I sit, I must be measured on certain matters. So it's okay. Let's leave it there.
But the sort of revelations he's put out.
Which revelation? Revelation about
it doesn't surprise
much ado about nothing. Excuse me. Much ado about nothing. They should go to court or give the prosecution the opportunity, the defense opportunity to tell his story. Go and tell your story. Tell your story. Go to the court. Don't look for a court of convenience. Don't look for a judge of your choice. Don't manipulate the court.
But Attorney General cannot manipulate the court.
Oh, please. Oh, please.
How?
I'm saying that they should have the automated system of assigning cases. The automated system that Georgina Wood introduced. They should let that one function.
Did it function under talk of...
Of course, we've always had an automated system. I'm saying that they should allow it to function. Currently, they know what they are doing. But even so...
Did it function under Godfrey Dame?
Even so, you may succeed at one point. But a point higher, a level higher, you may not succeed. It may be at the High Court, you may think you have won. At the Court of Appeal, there will be three. At the Supreme Court, there will be 5 and 7. So, you cannot manipulate the essential ingredients.
I mean, are our courts that weak?
For instance,
to give an Attorney General that leeway to manipulate it?
They are creating an impression that they can make the court weak. That's the impression they are creating. From how they have hounded out the Chief Justice, how they so determined to get rid of her, and the way they have manipulated the entire system. Listen, 3 petitions were filed. We are told by the Council of State that they found prima facie evidence against the Chief Justice. So a referral is made to a committee made up of some judges and other eminent citizens as provided for by the Constitution. And what did we hear? Upon completing the hearing of one petition, and the committee is setting a date for the second petitioner's petition to be heard, the second petitioner's lawyers caused a letter. The second petitioner's lawyers wrote to the committee asking for a long date. Which means they were not even ready. They who had petitioned were not ready for their case to be heard. Out of the blue, a report is prepared and sent to the president. You gave the person on the 15th that come for the hearing of the second petition. On the 2nd, a report was already prepared. Within 2 hours, Chief Justice is removed. Read in between the lines.
Last week, Tadio Sori was in the same scene.
And what did he say?
I asked him the same question. He says he was also given the same timeline to file the address.
I'm not talking about even the filing of addresses. Please.
That's not what you're referring to.
No. I'm not going into that one. I am saying that you referred 3 petitions. The committee was seized with 3 petitions. With respect, Tadio Sori is my very respected senior. In fact, he inspired me a lot at the bar. And I would always respect him. He knows that. I know that. We have respect for each other. But I know that senior Tadio Sori, wearing that legal hat that I so much respect him for, would argue any day against the conduct of the committee within the context of receiving 3 petitions, referred to them, and they're saying that they are done with 1, so they are done with their work. What they have done has basically rendered the 2 other petitions odious.
Yeah, of course. Well, there's nothing wrong with that, is it?
You think so?
I mean, if they found her guilty on one, it's enough, is it not?
Oh, so the others don't matter. I'm saying that I want lawyers who have practiced the law, and we respect them for that, to state publicly for posterity to record them, and we'll make reference to them someday. In any event, again, listen to something. My Lord Bafuboni, who is the beneficiary of all of this, was in a hurry to abridge time for the hearing of the injunction applications. Whereas in the substantive matter, he was not in a hurry to hear them. Did you see what the Attorney General filed? Now asking for extension of time. Meanwhile, there is a nomination before Parliament for Parliament to vet and approve. And then you have a case at the Supreme Court. And I'm making this appeal to all the judges at the Supreme Court.
That
they should know that now it is they, the courts, that are undermining the very rule of law. Because
how exactly?
One of your colleagues, a matter is before you. You know that it affects her rights. You were in a hurry to hear the injunction applications, and you determine it. There's a substantive matter that touches on the law. You could use the same haste to determine it. Why are they still in abeyance? Why is the Attorney General refusing to file the necessary processes and is now asking for extension of time? In the ECOWAS court, processes that were filed, the AG has still not filed a response. Why? So you want to shut your eyes on them, quickly put in Bafuboni, so then you've rendered everything nugatory. That's what you want to achieve.
But you know these same accusations were leveled against Tokono.
That's what did she do?
That in cases that suited her,
which
she
cases
quickly had it quickly.
Specifically?
In fact, in one of the petitions against the CJ,
yes,
they mentioned
Afenyo
one of the exactly.
But Afenyo
was a case in point.
Hold on. What did she do wrong in the Afenyo marking case? A constitutional matter of that urgent nature had been occasioned by a pronouncement by the speaker. Government business had been stalled, and you don't think that a constitutional court had a bona fide responsibility in that circumstance to consider and determine the matter, I'm surprised. Why those arguments? People trivialize everything. In any event, what was her interest in the Afenyo marking case against the speaker? What was Tokonu's interest? The Chief Justice, what was her interest? Did she have any interest personal to her other than the Constitution?
The accusation is that she had an MPP interest.
Oh, come on.
That's the accusation.
Let's be fair. Let's be fair. So Bafuboni also has an NDC interest. That is why he was in a hurry to empanel, to abridge time, to determine the injunction, get them dismissed, but the substantive matter, she will shut his eyes on it. I'm waiting on when my Lord Bafuboni would empanel the court to look into the substantive matters, those by the Chief Justice herself and other civil society organizations, even the High Court.
You're saying
even the High Court one.
You're alleging that they actually Bafuboni is slowing down this particular case to advance his own personal interest
by his conduct. It's obvious. By his conduct, but otherwise, what is he waiting for? The matter is before you. Why he has the responsibility to empanel. In any event, there's also another matter. The one challenging the warrant of a removal at the High Court. You know, the Attorney General has made a referral to the Supreme Court for interpretation. Why has that one not been heard? Why are they not adding speed? This is not the first time. You refer to the matter of Afenyo marking as that the court was in a hurry. In the Ayine Mensa case, my Lord Atuguba was the president in that 7-member panel. In the Zanato case, where a referral was made to the Supreme Court, challenging suitability to contest as a member on the ticket of the NDC, it was expeditiously considered. All right? So it is not the first time that a court has looked at the circumstances of the case and decided to waive the timelines for the final processes, even under Bafuboni himself, my Lord Bafuboni himself. All the injunction applications, he waived the requirement for 14 days.
On the subject of the removal of the CJ.
Let me conclude on that.
Briefly.
He waived the requirement for that 14-day notice where you have 7 days to receive and then file an order. He waived it within days. 3-4 days, the matter was heard and determined. With respect.
On that subject of the removal of the CJ, you've said, quote, the removal of the Chief Justice lacks transparency. The so-called Puaman report remains a secret document, and we, the minority...
But have you seen,
Just a second, I'll come to that. We, the minority, shall not relent on our demand for a copy and full disclosure of this report. What's the progress on this?
Oh, we have all our cards on the table. We'll make known to the country how we intend proceeding on it with time.
How exactly?
Step by step.
You said this some time back.
We are in Parliament.
What processes do you plan to activate?
We have the rules in Parliament.
To get this?
Don't worry. You will get to know.
Because it is now the preserve of the president.
Don't worry.
It was given to him.
We'll use appropriate rules provided for by law to demand for...
But there's no precedent for this, right? The last time anybody was removed under Article 146, I don't recall that the full report was published.
It doesn't matter. Let us invoke the law. There's always a first time.
Also because the process must be in camera. So the entire constitutional architecture was designed to keep it in secret.
So that the public legitimate expectation to know.
Well, until review the Constitution,
you see,
it is a law.
No, you see, that is, with the greatest respect, a rather myopic way of interpreting that provision. Yes, in camera, to the extent that you want to ensure some decency in the manner you handle the matter. But if it is in the public interest, the public interest rule will require that the citizens are informed. If you say misbehavior, stated misbehavior, and therefore the woman should lose all her entitlement, lose her office and all. Any stakeholder in an enterprise like this would want to know. And that is a legitimate demand and nothing more. So I think that it is appropriate, especially...
But you're dealing with the constitutional provision.
Especially I'm saying that the constitutional provision must be interpreted.
So you're going to Supreme Court?
In a manner... Oh, you still want...
Because you use the word interpreted.
You want to...
Once you use the word...
But you are interpreting, somebody is interpreting. Those who are interpreting it, giving meaning to it, haven't gone for court.
So will you go to the Supreme Court?
Oh, please, I'm saying that there are rules of procedures. There are ways to look for, get answers. We would explore that, rather respectfully and decently.
Will you vet Bafo-Bonny?
Oh, all our cards are on the table. We'll get there.
Including not vetting him and boycotting the vetting. Because you are the ranking on that. You are the vice chair.
Boycotting is out.
So categorically, you will not boycott
We will not boycott it. Anybody who is expecting us to boycott, I say here and now, we will never boycott it.
So what will you do instead?
We will do what is right. He himself must know that there is a Chief Justice. He himself must know.